Welcome to the Life Force Canada podcast. I am Karen. As you know, we meet here every week. We're here to remind you of your true self beyond the birth certificate, beyond your social insurance ID, your driver's identification. You are here on earth to ascend, to rise up from the false narratives and awaken to your true divine connection, your divine inheritance as a living woman and man. We are actually going to get right into our topic this evening, which is equity law with Julian Swan. Maggie Swan is here as well. Very exciting because we've had Julian Maggie on our private member call a couple times now, and everyone just fell in love with them and what they had to say. So we decided to have Julian and Maggie back on our podcast here. Now, a little bit of background on Julian. He left a career in architectural engineering and to really pursue teaching and coaching equity jurisprudence. He states that the system is very broken, but it is rarely corrupt. Since law is written to favor those in power, they rarely need to break their own laws. And he says that we can use the system to our advantage if we learn its inner workings. So just as a reminder, as Jillian is sharing the presentation, if you do have a question, please put it in the chat. And then after the presentation, Esther will start the Q&A portion of the podcast. And Esther will put in the chat the example. So just write the word question and then ask your question. Jillian, thank you for joining us. Maggie, it's so great to see you. We're grateful that you are presenting this very important topic. I'm just going to hand over the torch to you.
Awesome. Thank you so much, Karen, and everybody for this opportunity to speak to everybody here. My name is Julian Swan. This is my wife, Margaret, and we teach equity jurisprudence and how to set up trusts and other legal entities in combination with that in order to provide everybody with just the utmost protection. So I'd just like to speak a blessing over everybody tonight, and then we'll get underway. Father, I just thank you so much for this wonderful opportunity, for all the hearts and minds that you have called here tonight, Lord, and just the way that you are acting in all of your children's lives to bring us into the highest calling of our fullest potential that you prepared for us in the workshops of eternity before even the dawn of time. So I just ask you, Lord, to guide everyone here tonight into that high calling that you have prepared them for, and just use us and teach us and guide us. In Jesus' name. Amen. Right. Thank you so much. I'm going to go ahead and share my screen here. Now, some of this stuff we kind of went over already in the previous presentation, so I'm going to give a little bit different rundown this time and try to skip over what you've already heard. So our next class begins July 16th. And some of the Life Force members have been through our previous series that we just got done with. Hopefully, a couple of them will be sharing their experience tonight. And yeah, we're just going to keep on rolling. We got a massive influx of Canadian students during the last series, about 20, maybe 25. And they're already busy bringing equity to their lives in various situations, and one really cool win so far. And they just got done with the class, so the win comes from one that we started working with a little bit earlier in a private coaching capacity. So he got kind of a jump start. So that series just wrapped up a couple of weeks ago. But what we're going to talk about tonight is some equity basics, and of course the topic of going toe to toe with the judge. What that looks like, what it feels like. We're going to touch on trusts and PMAs and ministries briefly. I'm going to give some great testimonies and just talk about our cause. So as I'm sure most of you are aware, if you look up equity in Black's Law Dictionary, it says that it's a more perfect remedy or seeks a higher remedy than that which is available at the strict common law. Common law is very rote, dependent upon strict adherence to form, whereas equity is more forgiving, and it actually gives judges a very broad discretion to go beyond what the rigid law says and give a more just remedy. At least that's the way it was designed about 700 years ago in English chancery courts. In the modern day, equity is usually used against us, actually, because it gives judges such a broad discretion. Well, in the modern day, it's been used against us to a large degree. Think of things like injunctions, or when a court thinks that somebody's trying to use a trust to evade taxes, they can constructively unmake that trust and then take the money as if it was in that person's name. Um, that is actually an equitable remedy that's available to the plaintiff or the prosecutor in that case. So there's a number of ways that equity has been turned against us. So they're very used to using it. They're just not used to seeing it used against, used to transmute their attacks. And so that's where we come in. So here's a quote by John Bouvier, and his dictionary is probably sitting on many of your desktops or on your computers. He said, "Law is nothing without equity, and equity is everything, even without law. Those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have a weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted or those whose visual organs are deficient. Equity in its true and genuine meaning is the soul and spirit of the law. Positive law is construed and rational law is made by it." So one reason that all of this works is that we're going to see later, first of all, that equity makes you the accounting defendant. But of course, that would require you to pay up. And we'll go into what I mean by that. But prior to the 1930s, you could bring equity to court and you would simply have to pay with gold or silver. After the 1930s, the entire Western world went bankrupt. This is partially because of the economic depression, but it was also because of the reparations repayment plans. The U.S. and other Western countries entered into an agreement to help Germany repay reparations, which really just wound up bankrupting us and most of the Western world. So Canada gave up the gold standard beginning in 1931 and finishing in 1934. The US, it was in 1933, and really just across the Western world in the early 1930s. In the US, they needed to figure out a way to get around the Constitution's gold clause that required all money to be backed by gold and silver. But in Canada, they didn't even have that issue. They just ran it through, and there was already a remedy in the Bills of Exchange Act. That remedy is that negotiable instruments pass freely on their face as a substitute for money. And with equity, we can access that remedy. So contracts are supreme. That's not without caveat, even in the U.S., even with our Constitution, Article 1, Section 10, Clause 1, that contract clause was still violated in 1933 when they undid any contract that required gold for a form of payment. Like I said, in Canada, they didn't have that problem. They were able to just run it through without having to have any kind of constitution to get in the way. Thankfully, they passed the charter later on. But Bills of Exchange Act is what set up the ability for them to do that. And even though there is no equivalent of the contracts clause in Canada, contracts still reign supreme. The Pacta Sunt Servanda is a guiding maxim in Canadian law. It just means agreements must be kept. And Canadian courts, Australian courts, and all across the Western world all rigorously enforce the rights and obligations of contracts. The reason why we touch on that is because we've all entered into contracts throughout our lives. The birth certificate, the SIN, voter registration, driver's licenses, vehicle insurance, house insurance. I mean, there's tons of contracts that we've gotten ourselves into. And some people like to say, well, I was just a baby when the worst of those contracts were made. However, you went on to accept the benefits of those contracts later in life. You use that SIN and that birth certificate account to help you, open a bank account, to get a driver's license, or whatever the case may be. And we're just raised to, take these benefits like it's second nature. What we weren't taught is that those are actually adhesion contracts. And once you accept the benefits, you really have no right to claim that the contract was unconscionable just because you were a baby when it was made. It's a twisted system. It's a broken system, but that is the system of honor that these courts are going by. Once you accept the benefit, you can't really go back and say that it wasn't a conscionable contract. So we've gotten ourselves into this position with the birth certificate, the SIN, where we are now what is called a voluntary surety. We have entered into these contracts, really received no real benefit in return other than not having to go through a hassle to set up a bank account. So we what do we do with ourselves now that we're in that position of voluntary surety? Well, equity requires no particular status, as we're going to get into in a bit. And we don't mind being the surety in equity because we have a remedy to satisfy any debts or any charges brought against us in that capacity. In equity, the position of the defendant is preferred. This is actually a maxim of equity. A maxim cannot be argued. And if you haven't been getting preferential treatment as a defendant when you're dealing with banks or courts, then maybe it's time you tried something new. And I just talked about the supremacy of contracts, but equity actually gives you a remedy to unmake a contract so long as it fits into a certain caveat. Caveat we use is that you entered into it by mistake. And equitable rescission gives you the ability to unmake any contract that is haunting you or that is causing issues in your life. Say you filled out something with the CRA that you shouldn't have. Say you signed a decree from the court saying that you would pay somebody for the rest of their lives. These contracts are what originated the issues that you're facing, and equity gives you a remedy to unmake them, so long as they were by mistake. And of course, nobody can really tell you that you didn't make a mistake. It's very subjective. But you have to know how to stay in equity in order to enforce that remedy. There is commercial rescission as well, but it's only available to you within 72 hours of signing. And then beyond that, you have to actually ask a court to let you do it. So not very useful. Equitable rescission can unmake contracts for the cause of a mistake, and there's no time limit on it. So even if you signed something 30 years ago, it's still giving you pain. You can unmake it as long as you know how to stay in equity. So as I said, equity requires no particular status. You can begin learning right away. Our class is tailored for beginners as well as experts. Status change is a whole other area. It's not something I really deal with. I realize that people like to do that on principle, and I have no problem with that. And it's a great way for people to break the mold in their lives if that's what they choose to do. I'm just saying it's not required in equity. Definition of at in Black's Law Dictionary, one of them is near. So when attorneys say they are attorney at law, it really means they're near the law. And in equity, we give you the ability to operate in the law. Equity is the highest jurisdiction because it strives at the most ethical remedy, which is what the law is supposed to be all about. And while it is the highest jurisdiction, it can also be the most fragile, and it's the easiest to come out of if you don't know how to stay in it. Basically, as soon as you start arguing. And there's a number of other adhesion contracts as well that we watch out for. And of course, attorneys can't do it for you. As I said, they're at law. We operate in law. And so attorneys really aren't even allowed to bring equity. In equity, we teach the art of inquiry. And this is how we get facts onto the record without arguing. Very important not to argue, because the entire reason courts were created, and you can find this in the founding documents of any Western country, courts were created to eliminate controversy. So two people have a disagreement, and the court has to come in and settle the disagreement. Anytime that you make a claim, or you testify, or you argue, or you file evidence against something or in support of something, you are creating controversy. So why would you go to the one venue that's created to eliminate controversy and then make a bunch of controversy? Of course, you're just going to be giving the judge full ability to adjudicate over your life. So I realize, arguing is very popular in commercial law. That's what all the attorneys do. It's very popular in common law as well. But in equity, we do not argue. We don't testify at all. We just ask questions in order to get facts onto the record. And this allows us to stay in honor and avoid the court's adhesion contracts, which come with the whole notion of controversy. Equity is about coming in peace and staying in honor. So we don't argue facts, jurisdiction, law, or venue. We never challenge jurisdiction. We don't file anything. We don't testify. We just ask the questions that compel the performance that we want to see happen. We use the law of notice, and our questions are far more powerful than any argument that could be dreamed up. So we can't pay for anything because there is no lawful money in circulation. If there's no gold-backed money, then how do we settle charges? Well, with equity, we can discharge any charge according to the remedy established with the Bills of Exchange Act. So any debt, any criminal charge, any warrant, any court order, citation, whatever, it can all be discharged lawfully and honorably. If you look in Black's Law under the definition of discharge, you'll see under the subheader equity practice, it says, in the process of accounting before a master in chancery, the discharge is a statement of expenses and counterclaims brought in and filed by way of set-off by the accounting defendant, which follows the charge in order. Now, set-off and counterclaim are accounting terms. Of course, equity makes you the accounting defendant. And master in chancery is anyone that can take an oath. So any judge in any court can be made into a chancellor. You just have to talk right and appear in a certain way and use equity. There are two positions in law. We have honor and dishonor. And this is pretty fundamental. It goes back.
And I'm like, okay, I might do you need to pick one, right?
Sounds like somebody needs to be muted there. This goes back to Admiralty Maritime. It's a very curious system of honor. It's not something that we're taught. It's really originates with secret societies. I mean, Admiralty Maritime goes back to pirate days. All the most famous pirates were Freemasons. And this whole code of honor and dishonor it's commercial honor and dishonor, not necessarily moral honor and dishonor that you and me are taught. Basically, we're in honor when we accept responsibility, we forgive, we repent, and we transmute as opposed to resist and argue and fight. We're in dishonor when we argue, when we testify, when we file things, when we accuse, when we put claims against our brothers and sisters, and when we hire attorneys. So it's critical to remain in honor. If you're in honor, then you're not making controversy. If you're not making controversy, then the judge has nothing left to adjudicate over, and he just simply has to give you your remedy, especially if you've already paid the people that are asking you to pay with equity and with a proper negotiable instrument. I realize there's a lot of teachings out there about negotiable instruments. It's very common to see people paying with what they call bills of exchange. And occasionally I do see it work to discharge, utility bills or whatever the person's applying it to. But when you don't wrap it in equity, that is when you create controversy and you don't know how to avoid their adhesion contracts, it's really just a shot in the dark. But when you avoid their adhesion contracts, you're basically forcing their hand to give you the only remedy that's available, which is that negotiable instruments pass freely as a substitute for money. There's no controversy to adjudicate over, and so they are forced to give you your remedy. And it often comes down to a judge. Now, with unsecured debts, we see it just get settled with paperwork fairly often with banks, for loan situations. But when it's a more serious case, like a criminal matter or a secured debt, like a car loan or a mortgage, it's probably going to go to court. 95+% of the time, it's going to go to court. And the judge is the banker, so he's the one that can give you your remedy. And we spend a great deal of time preparing you for court so that you're ready for anything. And we'll get to that in just a moment. But basically, after the Bills of Exchange Act, the laws governing all commercial matters were updated to include payment or acceptance. So when our name is on something, we have a liability to honor it, And in the class, we're going to teach you how to accept presentments and demands and charges and loans and offers, and give proper notice to set off the accounting on any matter. And this is how we stay in honor and discharge all charges and debts and claims without arguing. I think we already covered this last time, but let's talk about going to court. Now, we have one student dealing with a criminal matter in Quebec right now. And, he started out with, I believe he started out with this secure party creditor process, if I recall. And so they're kind of giving him a hard time. When you start out with another process and then you transition to equity, they really test you. But if you stick with it, and as long as he sticks with it, then he will see remedy. And the precedence for that is in criminal cases in the US and Australia and New Zealand, where we've already seen victory. In Canada, we've had many victories in civil matters and tax matters. And we just got a massive influx of Canadian students, so we expect many more victories to be rolling in. 99% of the class material is the same between Canada and the US. Many of you may be surprised to know that. And then the things that are different, we have fully fleshed out. So what about going to court? Well, it's pretty much the exact same as anywhere else in the world. You have to stay in honor. You have to show up. You have to go to the place of judgment. Anybody can give you some templates and say, oh, they're not going to want to mess with you after this affidavit or whatever. But I would be a pretty awful teacher if I didn't prepare you for every eventuality. And the truth is that for a more serious case, it's almost always going to go to court. And even for an unsecured debt, it's more like 50-50 or more. So we spend a lot of time in the class preparing you for court. We have absolutely the best courtroom prep that I have ever seen. And I've looked at a lot of classes. I've talked to a lot of teachers out there. I've never seen anybody go as deep on the court stuff as we do. We have a very robust court script, but beyond the court script, we actually teach you the art of inquiry and teach you how to have a conversation with a judge. We do live role play with the students. We assist the students in scheduling to practice amongst each other and with us. And it's just so important because the judge can take you off script in a second. And you need to know how to divert the conversation, answer his questions with a question, obviously, but divert the conversation back to your goals. Because they've got a million ways of recontracting with you and getting you off into the weeds and down rabbit holes and such. So we thoroughly prepare you for that. We talk about the mind games that they play in court. Judges very often like to play dumb. They like to pretend to get angry and slam their gavel and talk to you in a fierce way sometimes. Especially in Quebec, they seem to like to do that. But we prepare you for these things, and we teach you how to appeal to the higher sense of honor that the judge, regardless of their bluster, is required to adhere to. Any court of Babylon can be transformed into a court of conscience, so long as you stay in equity and stay in honor. And so we go really deep on that. So, and I just wanted to touch on asset protection as well, because we just, back in February, we began offering a class on trusts and how to set up an equity trust system that operates fully in equity, that has layered protection, that insulates you fully from liability, and that goes deep on primary source research across the United States, Canada, and Australia to give you the absolute best practices in the worst case scenarios. And there are some key differences between Canadian trust law and US trust law, but we've fully fleshed that out. The main one is that trustees get named in their actual personal capacity, in trust for the trust, but still it's their name on the title, it's their name on the bank account. And there's some other important differences in Canadian trust law, but 90% of it is the same. Australia gets even crazier, so it's actually it's not as bad in Canada. But we had a lot of Canadian students join us for the last trust system class, And it was amazing. And we were able to go deep enough to where our students could actually teach their own trust class after fully internalizing everything. So we're not going to just, type up, like a 20, 30 page indenture and then, lock it so that you can't edit it. And then you got to keep coming back to us for updates. And we tell you it's a sacred document. You're not allowed to copy it. No, we don't do any of that. Instead, we teach you how to write your own indenture, how to set up your own entities. And, we don't want to be gurus. We don't want to force you to have to keep coming back to us. And we don't want to force you into, having to keep coming back and getting things edited and having to check in with us every time you want to change something in your documents. We teach you how to write them yourself and how to adhere to the absolute best practices for the absolute worst case scenarios so that you can be fully protected. Even in Canada, where, for example, the trucker convoy leadership had their bank accounts raided and frozen. So, we teach you how to protect yourselves from even that. It may require some diversification. It may require some layers of insulation, but we go deep on that in the trust class. So it's a separate class. We do touch on some of the more important key aspects, about bare minimum for how to protect yourself in the equity class. But if you want to go deep and fully learn how to do it the best way possible, it's a separate class. Basically, some major pointers I could give you are just do not be the trustee of your own stuff. And that is so common out there. And, for 99% of the stuff you're doing, it's going to work fine. I mean, you can be the trustee of your own stuff. You can live in the house. Technically, that makes you a beneficiary, but you're calling yourself the trustee. And a lot of these common law trusts and things tell you to just name your cat as the beneficiary or whatever. The problem with it is that, yeah, it works fine for day to day, but if it's ever scrutinized by the CRA or by a provincial tax authority or by a court, it's going to fall apart. And you can just look up things like the alter ego doctrine, look up things like the case law surrounding the role of the adversarial trustee. You cannot have an interest in the stuff, and you certainly can't be benefiting from the stuff. I mean, trustees can be compensated for their time, but they're not supposed to be just acting like beneficiaries. So that's one thing. And you can look up those, alter ego doctrine, adversarial trustee case law, and you can see that these trusts that make you trustee of your own stuff can be very easily pierced by tax agencies and courts. Another key tip that I can give you is don't wear more than one hat in the trust. And this is, it's just very important for, protecting the trustee's fiduciary responsibility and for minimizing your liability. And I could go deeper on this, but we're here to talk about equity tonight. So equity in conjunction with the trust system you're going to be able to, start a business, keep your business in the private, but have a public facing side of it and just, be able to discharge anything that comes in from the CRA. Now, you don't need the trust system to discharge things. Like the equity class can make you untouchable as a defendant, but we do recommend strong asset protection if you're dealing with student loans or government loans, anything where they don't require a court order to use their tools of liens, levies, and garnishments. While we're using our tools, they can still use their tools. Now, the CRA is more amenable. They don't go into dishonor as quickly as, say, like in California, the state tax agency is terrible. In California, we require asset protection for any students dealing with tax issues. But it's not absolutely required outside of California. For example, the student that we were talking about earlier, he's in Quebec. He discharged his provincial taxes with Quebec, and everybody thinks of Quebec as like the toughest one to deal with, right? Well, at least in this case, they went silent pretty quickly. So, and that's been several months, and no reply from them. So that's it for asset protection for tonight. We can talk about that separately if if your trustees would be gracious enough to have us back. But equity can give us freedom without having to memorize case law, rules of procedure, endless statutes and regulations. You can leave all that stuff for the attorneys or for the people trying to act like attorneys. Equity is above commercial law. And you'll also find maxims. We cover these in the class. You'll see that a maxim of law, as I said, it cannot be argued. And there's several maxims that speak to the fact that local custom supersedes the common law. Local custom is basically anything a judge comes up with, and if nobody challenges him on it and everybody just acquiesces, then it becomes a law. So local custom supersedes the common law. If the court says you can't do some common law cause of action or some common law remedy has to fit within a box that you didn't even know about, then you're just out of luck if you're in common law. But you will not find any maxims that state that anything supersedes equity. You will find the one maxim that people in the common law like to throw at equity, and it's, in my opinion, it's because of a lack of understanding, is equity follows the law. It's a maxim of equity. So the way that this gets interpreted by the courts is that equity can only be used when the law is not sufficient to provide the most ethical outcome. Well, that's true. However, in the modern day, when the courts are generating bonds on every account, which is a whole other subject I'm sure most of you are familiar with, when the court is generating a profit off of every case that comes before it, where's your ethical remedy in the commercial law or the common law? You can't get one. You have to be the accounting defendant at that point because they've made everything into a commercial matter, and the only way to pay these massive amounts that they're securitizing and derivatizing and ginning up in these markets is to pay with the remedy that we have in equity. Unless you're a billionaire, I mean, then you could meet the requirements of those kind of numbers, but much easier to just learn equity. So this is why we say freedom is a choice, because we have an instinctual desire to argue and fight when somebody's doing wrong to us. And the modern system has thrown the most ethical remedies out the window in terms of what they offer you. So you have to be the one to bring it. You have to choose to come out of arguing, come out of fighting, and transmute their attacks in peace and in honor, as opposed to resisting them and fighting them. So when you are ready to make that leap, then we can walk hand in hand with you with that. Now, the entire matrix or system, or whatever you want to call it, is run on the principle of secrets and fictions. There's secret trusts, there's secret statutes, secret language definitions, secret terms, secret contracts, and secret conditions of those contracts. And court is all about hidden contracts with hidden terms, and they penalize you for not knowing what those terms were. This is like the adhesion contracts that I speak to. But on the other hand, all remedy is based on exposing the matrix presumptions in one form or another. And this has never been more true than the modern day. Matrix presumptions like, you are this fictional entity. Well, we use equitable questions and notices to compel performance that we want to happen by pricking their conscience and implying or exposing their liability. So if we were accused of being a fictional entity or presumed to be so by a court, we would simply question, is that so? And we have hundreds of questions that we use to go deeper on that. Not that it gets that complicated, really. I mean, once you learn this to a high enough level, your court script can fit on one page. And it's just some very high level questions that we go in and ask, and we know how to divert the judge back to our goals. But equity is based on God's word, and it allows for the courts of Babylon to become courts of conscience, where miracles can and do happen. And we've seen plenty of them. So we come, we stay, and we leave in honor. We use their laws and their commercial procedures, but we don't testify, and we wrap them in a vessel of equity. We ask questions, and we stay in honor. And when we stay in equity, there is remedy 100% of the time. That has always been our experience. There's caveats to that, like you can't mix equity with anything. Like I said, you can come out of equity very easily if you don't know what you're doing. Just about every person that I see teaching equity out there, with the exception of a small handful, are mixing it with one process or another and arguing and trying to teach the court the law and saying, well, this is who I am. This is what the law says. You can't testify. You can't argue. You can't create controversy. They know what the law is. You don't have to tell them. They know well that they're operating in a fictional fiat system. Um, so we don't teach them law, and we stay in equity by not mixing it with anything, fully internalizing the process, and sticking with it. And as long as you're doing those three things, you see remedy 100% of the time. That has always been our experience. Here are all the places where equity has succeeded so far. That's the US, Canada, Australia, New Zealand, the UK, and Ireland, and even France. Our notices have been translated into French, both in France and in Quebec. And, we really enjoy the part of the job that requires us to adapt the class to a new country. We have one student in Australia in particular. We only have a small handful of Australian students, but one of them has applied equity in amazing ways in her life. She still has a health clinic, like alternative health practices, and she stayed open during the fake virus. And she racked up about $100,000 in fines, and she used equity to discharge it. And then numerous traffic matters, because she lives in Victoria, which is like the most severe state in Australia. And they're really serious about traffic down there. And she's discharged all her traffic matters, thousands more dollars in traffic fines discharged, and just really incredible victories. She stood in court in total confidence and just did amazing. As I said, we had a recent student in Quebec that discharged provincial taxes. Quebec student dealing with criminal charges. That's still an ongoing matter, but we're seeing traction on that case. And many more victories that are going to roll in soon, because many of our Canadian students have begun bringing equity to their matters. And then, we've been doing this a couple of years, but there are other teachers who we learn from who also had Canadian students that saw many victories as well, with mortgages and income tax, property tax, and you name it. So let's talk about some testimonials. First of all, just our personal successes. Me and my wife do practice this ourselves. We don't just teach it. Before we ever started teaching equity, we applied it in our own lives for a full year. So we first learned this about 3.5 years ago, but we discharged a credit card. We discharged a credit card actually post-judgment, which tends to be a little more intensive. We discharged some IRS debt, and we received multiple letters stating no further action is needed on your account. We used our family Bible for a name change in Chancery Court, because we have a covenant marriage. We don't have the state get involved in our marriage. And where we were at the time, Tennessee, says that they don't recognize covenant marriage. But we actually compelled performance from the chancellor in the Chancery Court with the family Bible, not using IDs or anything. And he called my wife Mrs. Swan by the end of the hearing. Got my previous job to cease taking all taxes out of my check. It was like giving myself a raise. We teach you how to do this. It's been fully adapted to Canada and Australia. So not just the US is capable of doing that. It's actually a little bit easier in Canada for some particular reasons I won't get into tonight. But anybody can teach you, certain forms that you can use to do that, but it's a whole nother thing to do it without sounding like what they're trying to see as a sovereign citizen. That's a heavily propagandized term, and obviously, as you all know, it's an oxymoron. Unfortunately, when you tell people it's an oxymoron, it just makes them think you're even more of a sovereign citizen, because they all say that. But we teach you how to have that conversation with your employer to make you sound professional and like you're doing what you're supposed to, make you sound like a good citizen, and still compel them to stop taking withholdings out of your check. And then far more importantly, we teach you how to stay in honor with the CRA if they ever come asking you about it later. Another thing we did was we used equitable questions to compel our landlord to hold to a rent amount that was previously promised. And so there's been no increase in 4 years. And me personally, I've gotten out of 4 speeding tickets using the traffic stop script that we provide in the class. And I realize that's quite a lot of speeding in the last 2 years to get pulled over that many times. So I have calmed down on the roads a little bit. Much better to just not start problems in the first place. But we have a very good script that has gotten hundreds of students either let go with a warning or just let go entirely. And then that's just our successes. It's actually pretty minor, our successes compared to the things our students have done. We've discharged millions in IRS debts. We've discharged hundreds of thousands in CRA debts, discharged hundreds of thousands in state income tax, including provincial income tax in Quebec. We eliminated 42 years worth of criminal charges for a woman in Tennessee. We brought equity to her 1-year probation sentence. So this was a wild case, and it just really wrapped up a couple months ago. This woman started out using, she didn't know equity, and she was driving around with, really she had the normal tags on her car, but she had a license plate that's like, it says private, but like the I is a 1 and the A is a 4. I'm sure you've all seen it. She had that sitting in her rear view window, even though she had the normal tags on. And a cop pulled her over, and he like freaked out. Like, he called her a sovereign citizen, and he called in a bunch of backup. And this is like a sweet, like 63-year-old artist who's in the car with her 92-year-old father, just going to enjoy a day in the park. But they've been so heavily propagandized on this whole sovereign citizen thing that the cop was like trembling, like his hand was like over his holster, like shaking, this this sweet old lady. It was pathetic, but this is why you don't want to do this kind of stuff with cops. I mean, we go deep on this in the class, but it's just not a good idea to argue with them. It's not a good idea to use the Patriot plates, the private, whatever. We don't care about that inequity because we are able to discharge any charges that come against us as a result of entering into that driver's license contract. So we don't really go deep on that in the class. We provide some suggestions. There are a couple of things that you maybe can do if you're able to stand on them to have alternative forms of licensing. But it's not a focus of the class because we can discharge whatever it is anyway. It's much more important to be able to discharge with a judge than it is with a cop. We have a very good traffic stop script, but if he's getting all antsy, just let it be. Anyway, she did not let it be. She was pulled out of the car, arguing about her right to travel and such. They left her 92-year-old father in the car. Thankfully, her brother was there to take him home, and she spent the night in jail. And she was very upset. And what she wound up doing is putting liens on the magistrate over the jail and the police officers and the secretary of the jail. And basically, she turned what was a simple traffic case into a threat of 42 years in jail for putting liens on public officials. And the charge was called retaliation for a past action, was the actual name of the charge. And so there were 7 counts of that, each carrying 6 years. And so that's a threat of 42 years in jail. And for the first year or year and a half of the case, she was doing what we call Patriot processes, various things, issuing bonds to the court or doing silver certificates or just various forms of arguing and making claims. And then she found equity. And she worked with a couple of different equity teachers, but they weren't getting her across the finish line. And one of them was the person. Well, I won't go into all that, but suffice it to say, she was coming up to trial and she needed some help with the higher level aspects of the process, and that's when she came to us, and we were able to help her with that. In equity, when you start out on the wrong foot, I mean, equity goes back and corrects the errors, but they may take you all the way through a trial. They may take you all the way through sentencing. especially for a criminal matter. And she was found guilty on all counts during her trial. And then she went to sentencing. And instead of a threat of 42 years in prison, after we helped her with the higher level aspects of the process and got some incredible facts on the record in the form of a question and did some other things, 42 years became 1 year of probation. And we even brought equity to the year of probation. She compelled performance from the judge and the probation officer so that she is not bound to any of the terms of the probation agreement. All she has to do is show up for meetings. So just incredible story. And what a journey that she's been on. But she stuck with equity all the way through, and it did what it said it would do. And I have some other, I mean, that's not the only criminal case. There's several miracles that we've seen in major criminal cases. I can get into another one if we have time, but I want to talk about some of these other wins. We've discharged wage garnishments, and we actually got the money paid back. So this person was getting wage garnishments from child support, and he was wanting to provide for the family privately and not go through, not have to pay the court, then have the court pay the ex-wife and the child. So he was paying privately. The court wouldn't recognize it. They garnished his wages, sent a garnishment order to his employer, and we were able to discharge all of that. And the child support division actually sent the money back to his employer to give back to him. We've compelled plaintiffs to drop suits. Usually this is in unsecured debt matters, when it just gets dropped outright like that, or non-suited. It's another way they put it. If it's for a more serious case, it's usually going to go through a few hearings at least. Students have received certificates of release of federal tax liens. Students have discharged hospital bills, serious contempt charges. Our very first case was a woman in New Jersey whose dogs escaped, and the neighbors got mad and called the police. And it turns out the dogs weren't registered, and they were trying to vaccinate the dogs. And she started out doing a different form of equity. It's like what I would term a pre-1933 form of equity, because it deals with things like silver bonds. And anyway, we helped her unmake that stuff, come back into honor, bring what I would term post-1933 equity, or the form of equity we teach. And our very first case that we took on for somebody else, we won, and those dogs remain unvaccinated to this day. Discharge more credit cards than I can count. Of course, other kinds of unsecured loans as well. We've had attorneys removed from cases. We've got arrest warrants discharged. We've taught students how to talk to judges and actually help them compel discharge during a court hearing. And we've even improved relations between parents and family court, which is, it's always beautiful to see people work it out outside of court. And when you are doing all this arguing and testifying and fighting, and then you learn equity and know that the way of peace actually carries more power than all of that stuff, it can actually go a long way to mending those relationships. So we've seen that as well, thank God. And so that's just the wins, like obviously the law wins are what most people are after. But there's a lot of spiritual wins that we get in this class as well. And I mean, like I said, when you're doing all this fighting and resisting, and then you learn how to operate in honor and in peace and transmute things instead of resist them, then it's just so powerful. It's transforming for people. It's life-changing. And so these are just a few testimonies that we've gotten from students about that. And I think I read these the last time I gave a presentation, so I'll just move on. But it's incredibly powerful, the spiritual change that comes upon people when they learn how to access the power that God made available for us. And the Sermon on the Mount, Matthew 5, 6, and 7, just detail it beautifully. And some of those verses are foundational to equity law itself. But yeah, the way of peace and soft power carries far more weight than any argument ever could. And so I'll leave these up for a second if you want to read over them. I already gave these testimonies previously, but you can pause the recording. And here's some more wins that our students got, but I got to watch my time, so I'm just going to keep moving on. You can pause the recording if you want to look at these. So imagine never having to worry about going to the mailbox, getting a knock at the door, seeing lights in your rearview mirror, or receiving a call from a debt collector or a tax agency, or being challenged on anything ever again. That is what equity is all about. It's an advanced course. It's going to teach you everything that you need to know about being untouchable as a defendant and just being left the heck alone. Obviously, there are not just lifetime benefits, but generational benefits to that. We're going to run for 13 weeks. We meet on Wednesday evenings. We run for 2 to 3 hours per class. It's graduate level material. If you count all the small stuff, like compelling our landlord or getting let go at a traffic stop, whatever, there are thousands of victories from our students. And if you count all the major stuff, there are hundreds of life-changing major victories. Like I said, everyone who sticks with it, doesn't mix it with anything, and uses all the tools that we teach will see remedy in their lives. And it's just incredible to be a part of such a effective and powerful process. And there's a couple other really cool cases I could talk about, but I'm not sure how we are on time. So, if our hosts are gracious with that, I could talk about them if y'all want. Of course, their graciousness is not dependent on that, of course, or we could just move on to questions. But you could sign up at the website, standingontherock.com. Right now, the website's still under construction. It's in the final hours of construction. So if you're watching this recording, it'll probably be available then. But at the moment, it's still in a alpha or beta form or whatever they're calling it. So instead, you can contact me on Telegram at @vitiate0. You can also email me at julianswan@proton.me, and I can get you all set up. And there you have it.
This is fantastic, Julian. Thank you
you.
so much for all you do. I know there's quite a few questions in the chat, so I'm going to just pass it over to Esther.
Thank you, Karen. Thank you, Julian. The first question, I'm going to go in order. We may not get to them all because some of these are, well, all the questions are great, and we just may not get to them all in terms of time because some of them might require more in-depth answers. So let's start at the beginning. Len asks, in all my research, I cannot find a thing about Canada ever going bankrupt. Could you provide a link for us? He says, I want peace of mind about this subject. Thank you.
Sure. So Canada moved off the gold standard and beginning in 1931 and culminating in 1934. And I mean, the money isn't backed by anything now. So that in and of itself is basically equivalent to bankruptcy. I mean, it's basically it's the same in the US. I mean, they won't tell you that the US is bankrupt, but there's nothing backing the money anymore. And all the gold was moved offshore. I mean, Fort Knox is empty as far as I know. So the same thing in Canada. I mean, the whole economy runs off of negotiable instruments.
Just tell you how deep in debt we are.
Yeah, they just keep telling you how deep in debt we are. I mean, the national debt is evidence of the bankruptcy alone. I mean, it's insane in the US, but it's pretty much just as insane in Canada. It's just a slightly lower number. So yeah, I mean, the evidence of the bankruptcy is all around you. You're not going to find official documents saying we've gone bankrupt, but I mean,
Google won't tell you that.
yeah, but I mean, the national debt, the fact that there's nothing backing the money, and the fact that negotiable instruments are the only remedy that we have left is all the proof you need there.
Thank you. Cher asks, can this work? I'm assuming that means equity. Can this work for doctors who have lost their licenses due to the pandemic, or is this a very different situation as it has to do with the medical system?
So that's a very interesting subject, and we actually have a couple of doctors that we're in touch with about that. Equity can be used to compel performance in any situation. Now, for that specific of a thing, I mean, you are seeking a benefit to have, their licensing. The equity trust system that we set up allows you to operate without a business license, but professional licenses are often still required. So it's a tricky subject. We're delving deep into some areas that underpin the modern framework for all the laws revolving around medicine and its practice. So we don't have a full solution for that at the moment, but we are working on it. We have some incredibly powerful stuff that I'm not seeing anybody else talking about. So get with us, and
We do have a student working on that right now in the US, right?
yeah. Yeah, and I mean we're working with a couple of people and fleshing out some things. There's some really interesting stuff about if you go back to what makes up the fundamental underpinning for medical law in the Western world, it goes down to some really shaky ground, but you got to be able to parse out the definitions and the words. And so it's my opinion that this can be used to compel performance from medical boards. But oh, and I'll just say, and with all things, we bring to light what they're doing in the dark. And there's some incredibly damning things about laws surrounding vaccines and other medical interventions. And like I said, just the fundamental underpinnings of medical law in the first place, the definitions they're using that can really do some damage. So we're still fleshing that out. Very interesting question. But right now, it's not like a turnkey solution.
Thank you. Deborah asks a number of questions. The first one, if one of your students ends up in court, do you or somebody go with them as an observer or coach?
If it was local, or in certain situations, like if we've been helping them for a long time, in a criminal case or something, we might fly out for that. But we do a incredible amount of practice with our students, especially in private coaching situations where it's like a more serious case, preparing them for court because we have a ton of experience in court. But you have to be the one to bring equity. You can't have somebody else bring it for you. I would love to go and observe in any chance that I can. But as far as like representing somebody else, I wouldn't be able to do that. You would have to be the one bringing equity.
Thank you. Ian asks, you referred to a trust indenture. Are you referring to an actual bond?
So a trust indenture is the founding document of a trust. It's like the contract of the trust. It's a contract between the grantor and the trustee. A bond would be a different concept. An indenture is just a specific type of contract that forms a trust.
Okay. Nicole asks, can you give specific Canadian victories over taxes, debt, mortgages? What are some types of responses that are coming back from the CRA or banks, etc.?
So, I mean, in Quebec, I mean, they just went silent. For CRA matters, we have spoken with some people that just talked about bringing equity and discharging it over a period of 6 months or a year. Sometimes it goes quicker, sometimes it takes a little longer. But the majority of our Canadian students just finished their class. So as far as specific victories, I just have a couple. But as I said, this remedy that you're learning, I mean, we believe we've carried it much further, but in some form or another, it's been taught since around 2012 or so. So there are other teachers that have had victories in Canada with their students for mortgages and things like that, property taxes, and I'm just going based off of their word on that. But I mean, we've seen in the U.S. and Australia and Canada so far, And I have no reason to believe that it's any different in any Western country.
Thank you. Glenda asks, is this important for people who have no debts and only a very small business that is already registered with the CRA and GST agency? Or perhaps you could explain the possible benefits, please, for this situation. Thank you.
Yeah, so a lot of our students take the class or both classes just to be prepared, because you don't have to be doing something wrong to come under the ire of the state. There's plenty of people that I talk to that are, I mean, basically everyone that I talk to with a criminal case is innocent. We don't help people that, harmed others. So yeah, there's just, you always want to be prepared. I mean,
Well, and we all know that from after the fake COVID stuff that, there's tyranny, and this gives you a way if there's a knock at the door, if there's a telephone call, if you're trying to visit somebody at the hospital and they won't let you in, if somebody's trying to make you wear a mask, take a vaccine, whatever, equity gives you the art of inquiry where you can deal with that kind of force without fighting or arguing. We just teach how to ask the questions that compel the performance that you want to happen. We just had a woman student talk about today that she was so scared of the tax board that she quit trying to make money. She didn't want to make too much money, and she didn't want to have her business grow because she didn't want the tax board to come after her. So, it just gives you a level of comfort and to be sure about your life and know how to stand in every situation.
yeah, and even if you just have a small business, I mean, you're still tithing to Babylon, by being registered with the CRA and filling out their forms and, paying with your Canadian banknotes. So instead, you can pay with a negotiable instrument and set your business up so that you can be confident that it can't be taken from you. And so that's what we offer.
Thank you. Deborah asks, at what point when one is in court, does one make this court an equity court? Who starts that conversation?
We do. We have to be the ones to start it because they're not going to do it for us. So that's, we do that initially with our paperwork. And then when we go in and speak to the judge, it becomes very clear to him very quickly what we're doing.
And Tara asks, and I think you've answered it, but let's just ask for clarity. Can this process help with foreclosure?
Yes, absolutely. And there are a number of people that will live in their homes debt-free for the rest of their lives, thanks to equity.
Fabulous. Stan asks, can special appearance paperwork substitute for actual court appearance when using your equity process?
Nothing can substitute for court appearance with any process. We do appear specially. That's one part of it, but you very quickly come out of a special appearance if you don't know how to stay in it. But no, I mean, special appearance is, you're saying you're appearing. I mean, it's in the title. So it's very important that you actually appear, and you can do so specially, and you should. But you got to show up to the place of judgment. I mean, the judge is the banker, so he's the one that can give you your remedy. And I know a lot of people are nervous about going to court. That's why we spend a lot of time on it. You're going to be a lot more confident about going to court once you go through our program.
Thank you. We have another question. And I know you've shared a number of testimonials and stories, but this is a specific question. Do you have testimonials from people in Canada who have successfully used this to discharge their mortgage and have all of their mortgage payments returned to them? If so, can you share this testimonial?
Well, first of all, as far as having mortgage payments returned, I don't believe that that's possible safely in any country. And I don't teach that. I understand that there's, tax filings that can be made. But I've seen cases where people do that, and then like 6 years later, they get a criminal case against them. So I realize you can do that, but it's just not something I feel comfortable with at the moment. And maybe if that was more fleshed out for me, I would feel differently. But I've just seen too many nightmare stories on that. Now, as far as just mortgage discharge, like discharging the rest of the mortgage, not necessarily getting back what you've already paid. I think I mentioned that, some former teachers of equity had some successes with Canadians in that regard, but I'm just relying on their word for that. I didn't get to talk to the Canadian students themselves.
Also, the process of discharging a mortgage is very intense and takes a lot of paperwork, a lot of commitment. It's still very stressful, especially if that's where you lay your head at night. And so not a whole lot of students do it. I mean, if somebody's actually already in foreclosure, then equity is the best remedy, but it's not something that you would just take on just for the heck of it.
Yeah, I wouldn't advise people take that on because it's very stressful. Now, I mean, as Maggie said, if you have no choice, equity is your best remedy by far. But it's going to be very dependent on your ability to withstand under a tremendous amount of pressure. Depending on the situation, you might only get like one or two appearances before a judge, before the house is sold at auction, or sometimes, it's even after the house is already sold and they're looking to evict that you would actually get a shot before the judge. So it can be very, very stressful.
It's not a silver bullet like, oh, I can just discharge my mortgage now. And it takes a deep level
Yeah.
of internalization of the material and commitment to staying in equity and practice. And so it's a challenge for sure.
And there's plenty of students that have done that. Like even in the US, we have non-judicial foreclosure states where it's after the house has already been sold at auction and they're looking for an unlawful detainer order to get the person out of the house. That's when they get their one shot in front of the judge. And there are students that have compelled discharge of the mortgage during that one hearing. But I mean, imagine the stress of that, especially if it's your primary residence. I mean, it's not something I would recommend. And we spend I like to give caveats on this because there's so many teachings out there that are just like, oh yeah, mortgage is fraud. Like all you have to do is say it's a fraud, and they'll just tell them you're the beneficiary, and they'll just give it all to you. And I mean, people embroil themselves in incredibly stressful nightmare situations because of these teachings, and it's like there's no silver bullets out there for anything. Even equity, you have to stand on it. Equity gives you absolutely the most powerful tools and the most powerful ability to stand in court and have that conversation with that judge. But these banks fight very hard for these assets, so it's a very intense process. We don't recommend it unless you've already got some wins under your belt. So that's our mortgage spiel.
Thank you. Yeah. So don't start with your mortgage. If you've got issues, start somewhere else
Right.
and learn the
Exactly.
process and get going on it. Okay, so we have a number of questions about your course, especially for us here in Canada. So I know that your course is done over Zoom and you record the sessions, and they're 2 to 3 hours, usually 3 hours per session. What is your teaching format for the equity course? Is it modules at your own pace or an interactive class? Do you test your students throughout the course? Who are your mentors in equity? I'll just put
So
those all out on the table.
yeah, good question. So it is an interactive class. We break for questions after each major section, and obviously at the end of every class, and we'll stay as long as required to answer all the questions. I love answering questions, and then the classes are recorded, so you always have access to the recordings, and future access. I mean, your access never goes away.
So if we do another equity class series, then you get access to the new class.
Right. Exactly. You get to freely attend all future equity classes. You're in for life just with the one payment.
Telegram.
And there's a alumni Telegram group. It's like a whole other class in and of itself, and it's beautiful to see all. We have over 200 students in there now, all bringing equity in various forms.
So new classes, Telegram group.
And then the new students get added to their own group. They go through the class, and then they get added to the alumni group.
Where they can ask questions.
Yes, and we're always available for that. And then as far as like what format is the class in? I mean, we go deep on primary source material so that we just back up absolutely everything we teach. Nothing that we teach is conjecture or opinion. It's either primary source material or direct repeated experience, and mostly primary source material. Also, we
We also give out an outline for each class, and it's a detailed outline so that students will have that. They can make notes on the outline, or they will be able to go back to the class and know where they can find certain information if they need to go back and revisit that section of the class.
Yeah, we've structured it and organized it very carefully. And then as far as who our mentors were, several people. They all like to remain private, but yeah, more than a couple.
Thank you. Nicole asks, many believe that in Canada it is the responsibility and obligation of the Office of the Public Guardian and Trustee to pay or discharge debts and utility bills, but we have to appoint them to do so. Is there a process using equity to notify the Office of the PG&T in this way and avoid going to court?
So when we deal with utilities, I mean, we don't do month-to-month discharge in equity because equity basically just nukes the whole account and closes it out and discharges both sides of the ledger and actually zeroes out everything, which coincidentally is also the only way to decrease the national debt is to pay the way that we teach you in equity because it zeroes out both sides of the ledger. But there's a maximum of equity that states that equity delights to do justice and not by halves. And by halves would be like month-to-month discharge. So equity just closes out everything, nukes the whole account on both sides of the ledger. So there's no month-to-month discharge in equity. I realize people, I think I mentioned this earlier, like they use bills of exchange to pay their utility bills. It's very hit or miss, almost never works. There's just not a great solution for the month-to-month thing. Now you can rack up a huge utility bill for like a year or two and then move somewhere else and then discharge the account, but
put it in somebody else's name.
Yeah, you put it in somebody else's name, but there's bigger things. You can rack up a credit card, just pay your utility bills with a credit card and then discharge the credit card. That's a perfectly viable option. So yeah, that's it for utilities.
Okay, thank you. And do you know anything about the Office of the Public Guardian and Trustee? Have you ever had any encounters with them?
So we don't no, to keep it short, no, we don't need to appoint public officials to handle the accounts for us. They just kind of pass it up the chain in our experience until it reaches the central bank. So whoever we're dealing with, sometimes we have to go over their head. And there's a number of different public officials that we may notice, but no one of them needs to be like specially appointed or anything.
Okay, thank you. Do you have examples in cases where equity has not worked and where the court or judge did not permit you to use equity?
As long as the 3 caveats I mentioned are followed, then we've seen remedy 100% of the time.
But when you're standing there, though, they're going to act like they don't know what you're talking about. So.
Oh yeah, that happens all the time.
And they never say, "Oh, congratulations, you brought equity and you win." They'll usually just silently discharge the case, or it just goes away, or something like that. So.
And I'm not talking about the thing where people are like, "Oh yeah, it's discharged" or whatever. They still got problems and they're still like, have arrest warrants or whatever. I'm talking like you stick with equity. Yes, they're probably going to make a huge scene in court, especially if there's other people in the courtroom that they don't want this getting out. But you will get discharged. You'll get a certificate of a release of a federal tax lien. You'll get a thank you for your payoff funds. You'll get the case just disappearing or the docket just going away entirely. You'll get discharge of the arrest warrant. So I'm not just talking about in theory it's discharged. We have numerous examples of real wins. But yeah, like Maggie said, they're not going to act like it. Nobody's going to stand up and clap and say, "Congrats, you win." Usually they come up with a statutory reason to dismiss the case or a procedural reason, or the case just disappears, or the attorney like non-suits the case, like the plaintiff's attorney that's suing you. There's a number of different ways it happens. We've had students actually, one student was put in handcuffs in court in front of everybody there. The judge said, "Take him to a holding cell." And the bailiffs led him to the back door of the court, took the handcuffs off him, pushed him out the back door and said, don't ever come back here again. And we've had students in criminal cases being threatened with years in prison, go all the way through trial, found guilty on all counts, go all the way through sentencing, sentenced to, 2 years, 5 years, whatever, and put in shackles, put in the back of a van, taken to jail, and then an hour and a half into their sentence, the jailer comes, opens the door, says the judge called and he said, your case has been discharged. You're free to go. So these are the kind of miracles that you see in equity. And the man that I just spoke of there in that incredible case, we were in frequent contact with him, and it's beautiful to see these things, and it's going to happen under cover of night. A stealthy opening of a cell door or a call from the judge in the background. It's never going to be out in the public. So
It would sure require a lot of courage to stand in equity, being taken away, being charged on all counts. I've heard your story before, Julian, but to be charged on all counts, taken away in handcuffs, thrown in jail, and not knowing what's going to happen, and standing firm in it, and an hour and a half later being let loose. I can't imagine that emotional journey of that man who was in that situation. It totally is a miracle.
He said it was actually quite freeing for him.
Wow. Amazing.
yeah, he said he has an amazing attitude about it. He said he was sitting under the courthouse when they first put him in shackles when he was waiting for the van, and he was like twisting around, like trying to see the shackle, like trying to see where it was manufactured. He's like, oh, I know they didn't put me in some Chinese shackles, like these got to be made in America. And it's like, wow, they were made in America. This is great. And then they put him in the back of the van, and he's like, wow, I'm getting a whole new perspective on this town that I grew up in. And very few people get to see it from this perspective. And so, yeah, just
this was too like a case where he started, it was traffic stuff and he had a Patriot license plate, and the cops would just kept pulling him over, and he just at first he wanted to fight it. So he was doing like all kinds of Patriot methods too. And he did all kinds of processes first before he started bringing equity. So he did a lot of fighting ahead of time.
Right. And usually in those cases where there's been a lot of fighting and you're transitioning and back into honor, they're going to take you right up into the line. And I mean, you're going to have to, dip your toe in the Red Sea before you see the waters part. But if you can maintain, they're trying to see if you just go screaming off into dishonor and start arguing and fighting. And then there would be no call from the judge. But if you stick with it, and it's very rare that anybody would ever have to do this, but if you stick with it, equity will work a miracle in your life.
Thank you. Stan asks, does mastering your course provide us with 100% freedom from the matrix?
I was going to say, because, I thought before somebody had asked about the, why to take this course if you don't have any debts or whatever. And we go into very deeply some spiritual aspects of what's going on in the world. And I think that speaks to this question as well. And one of the processes in equity is repentance. And it's we call it repenting of your sins, but it's talking about commercial dishonors that we repent of. But we go into the concept of repentance and also of forgiveness, which we talk a lot about forgiveness, because a lot of the people coming out of the matrix and the patriot world, and they have a lot of angry and revengeful thoughts, and they want to go after them, they want to get them, and they want to do that. So that's not what equity is about. And so we talk a lot about that. And we also talk about the spiritual element of what's going on in the matrix, and what's going on in the courtroom, what's going on behind the scenes, and what the spiritual component is. Because when you look up the meaning of equity, it'll talk about it's the spirit of something. And once you talk about spirit, you're in a spiritual realm, basically. And there is a battle going on, so we address that aspect of it.
Absolutely. And equity gives you all the tools you need to be as private as you want to, but to also be able to operate in the public and run a business and You know, I mean, especially for a business, you'd want to combine it with the trust system material, but I mean, equity gives you all the tools you need by itself, just with that class to be as private as you want to be, and still be able to operate in the public.
We're to be in the world, but not of.
Exactly.
Thank you. Brian M asks, do you have a driver's license, registration, and insurance? Either or both of you?
Yeah. So, you know, as I said before, I think that it's not a wise move to try to compel performance with a cop on the side of the road beyond a certain point. I mean, our traffic stop script does a good job, but we don't push it with them. You know, I sign restricted on my license, but it's really just or no, on my registration I sign restricted. It's really just like a flex. You know, it's not like that's going to get me out of a case or anything. But equity will discharge whatever is brought against me for being in that contract. And I mean, the roads are just locked down. I mean, it's a battle that the people have lost. You know, but thankfully, equity gives us a remedy to discharge any debt or charge brought against us for those contracts.
The roads are locked down, as well as it's their bread and butter. That's how they make their money in these local jurisdictions. There's a lot of patriot mythology out there that, oh, you can just stick this tag on there and you can just show them this piece of paper and it's all going to be fine. But it's not working, and people are getting in more and more trouble. So we don't recommend that.
It gets people labeled sovereign citizens. As soon as they call that code in over the radio, 6 cop cars show up. You know, they're dragging the person out of the car. And oftentimes it's like in the story I told earlier, it's just like some sweet little old lady that just, you know, wanted to talk about her right to travel with the cop. And I mean, they've been so heavily propagandized against this stuff. It's like, why pick that hill to die on, you know?
And they say, you know, people say, well, I have a right to travel or, you know, whatever, but really it's their roads, and even the VIN number on the car makes it their car, and then the licensing and all of that,
Yeah.
and the contracts that we've gotten ourselves into.
Exactly.
There's so much going on there, but
You have entered into contracts and you will be required to honor those contracts. Now, equity, you could rescission them. You know, that's more akin to a status change type of thing. If you want to rescission your driver's license, rescission your SIN, rescission your birth certificate, but that's not going to rescission it all the way in the highest database of the country. I mean, every time you get pulled over, you're still going to appear as that old person to the cop. Same thing with any status change process. So
we can teach you how to put your vehicle and the vehicle information into a trust. And then that way it's not in your name, and you're not operating it in your name. So the registration and the vehicle can be in the name. You still have to be a insured driver.
you're still going to be named on the insurance policy. I mean, that's more to protect you from creditors and stuff. But I mean, yeah, the whole right to travel thing. I mean, you gave up that right when you agreed to the contracts that you got yourself into, whether it be the driver's license or the SIN or the birth certificate that you continued to use the benefits of. So, and it's fine. You know, like I said, we do not mind being the surety in equity. You know, we're able to discharge anything brought against us because of that. So, you know, we got bigger fish to fry.
Thank you. Would it be better to borrow on unsecured loans and use the money to pay off your mortgage and then discharge your unsecured loans in equity, or will that put you in dishonor?
That will not put you in dishonor, and it's a perfectly viable strategy.
Okay. And if you discharge a credit card, will they cancel the card and make it unusable again? And I think you answered that before. The answer is yes.
Yes, that's correct. But it's not like they put you on a blacklist or something. I mean, you can go on and get another credit card even with the same bank.
Is that an easy thing?
So it depends on the credit score, essentially, just like, you know, basically for, we've seen the credit score go up when people bring equity. We've seen it go down. We've seen it, you know, tank and then come back up 3 months later to where it was before and then actually go up like a couple of points. So we see it all when we bring equity. I mean, the credit score is their benefit that we're kind of asking them for. So rather than have direct control over that in the moment when we're bringing equity to a credit card, we just come back and clean it up later with various notices to the credit bureaus. And there's also all sorts of credit repair processes out there. I mean, we're far from the only ones that can do that. But yeah, I mean, you can always get another credit card.
Thank you. Lorene asks, has anyone done any action on the UCC1 filing by Govinda Health Ministry? He claims all the groundwork has been done and all government agencies, WORLS, or maybe that's worldwide, are not committing fraud anytime they bill your strawman all caps name.
Yeah,
Maybe not,
well,
but-
I got a bridge in Ottawa to sell you.
There's been a lot of debunking of the Govinda stuff too. I mean, like people actually he gave the numbers to look up the UCC1 filings and you can't find them.
And even more than that, it's just like he recorded this in Travis County, Texas. So it's one little county. And then he's claiming that the debtors on the UCC1 are like the Vatican, the US Treasury, like the Pope. I don't know who all the people he put on this thing, but I mean, just because you file a security interest against somebody doesn't mean that like you own them now. Like there has to be there's three underlying components of a security interest that must be satisfied. You have to have a security agreement, something like a mortgage, for example, that justifies a lien. So security agreement, value, and consideration. Like you have to give some value, you have to receive something in return. So if you're naming the Vatican as the debtor, like what is the underlying security agreement that gives you a justifiable lien against the Vatican? I mean, you're just saying you have one, but there isn't one. And then just because you file it in Travis County, Texas, doesn't mean that like, the Bank of London is going to call you up the next day and turn over the keys to the vault. So in my opinion, it's really just theater. And then even worse than that, it's encouraging people to do the same in their own local areas, which is just going to ramp up the propaganda against sovereign citizens, quote unquote, and make it harder for people that actually have legitimate UCC1 filings or PPSA filings if you're in Canada. It's just going to make it harder for us to do it the right way. We'll still be able to do it, but it's just we're gonna have to compel more performance. So that's my opinion on that whole thing.
Okay, thank you. And we're coming to near the end here. Nicole asks, once you clear a CRA debt, do you recommend not filing again, filing a zero filing, filing in some other way? What do you recommend?
I mean, I recommend learning equity so that you actually are able to honor the CRA. You have to give them something that they recognize. And just doing a bill of exchange, I mean, maybe it'll work, maybe it won't. I mean, you need to know how to eliminate the controversy because they're very particular about being honored commercially. But to answer your question, generally, I would not file things with them.
So we say don't contract with them if don't make a contract with them, and that's what filing is.
Yeah.
Right, but if you've already contracted with them for your whole previous life up until this point, or not, maybe you haven't filed for say 5 years or 10 years or whatever, and they're coming after you, then you're in a whole different situation.
Bring equity.
How would you deal with that?
You can bring equity to either unmake those filings or just pay them whatever it is they're asking for without using your Canadian banknotes, and just come back into honor. And then from that point forward, just stop contracting with them.
And if
Great.
they send something else, which we call an offer, then
You'll always know what to do with it.
Okay. Does this align with the In Power movement? Cal Washington teaches extraction from licenses, insurances, etc.
I'm not super familiar with what he teaches, but equity does give you the tools to unmake those things, but you're still going to be assumed to be under those contracts by the authorities. No matter what kind of status change stuff you do, that's always going to be the case. So rather than doing all sorts of expensive status change paperwork and sending off stuff and waiting months to get a response and sending off another thing. Just recognize that you're the surety, not the beneficiary, and take joy in the fact that you have a remedy and equity to discharge any debts or charges brought against you in that capacity.
The thing is, if you're operating a vehicle or you're traveling internationally or whatever, the gatekeeper or the revenue agent beside the road is not going to recognize any status change documents or any of that stuff. And if you don't have what they expect you to have, then they're going to either boot you out or put you in jail. So it's, that's the truth. I mean, a lot of people do the status change on principle, but I don't think it really helps anywhere else.
Yeah, and it's fine on principle. I mean, it's a good idea, but just practically speaking, we need a deeper remedy than that.
And can you explain what you mean by the phrase, "you're the surety"?
Sure. So when you enter into these contracts, like the birth certificate or the SIN or the driver's license, there is an implied trust created where your all caps name is assumed to be the trustee, and the government assumes themselves to be the beneficiaries. And so you, as the living person, if the trustee gets into trouble, the surety has to come in and pay, whatever has been incurred, whatever debt or charge or claim the trustee got themselves into. So that is the capacity that we're in my opinion. And thankfully we are able to pay. They could say pay $1 million. Fine, equity has the remedy for it. So we pay them every penny they're asking for in that role.
Okay, and we're drawing near to the end of our questions here. Is it possible to stop the banks from withholding tax on RRSP withdrawals?
Yes. So for the savings plans, we prefer to do like a rollover into a qualifying plan with a company that is a little more friendly. So that's how we take care of that. It's really not even necessary to bring equity to that. Although people have, I mean, you can just keep it with that bank and compel performance with them, but it's going to take a while. There's other ways of doing that. We actually have some companies that we can recommend that'll do that for you.
And do you know if you can get a passport that is sovereign, or do you stick with regular conventional passports if you wish to do international travel? How do you handle that?
I've heard of people, submitting certain forms to the passport office and still getting just a regular passport, but the forms they submit, they feel are giving less information, or they feel it's a little more private. I just don't really concern myself with the status change stuff or the identification stuff. I know that I have a perfect remedy. I mean, people see that as an adhesion contract, sure. And it is
A benefit.
it is a benefit that you're receiving from the government. It is an adhesion contract, but it's too much hassle with no payoff to try and do the alternatives right now. They're just not robust enough. So instead, I just know that I can discharge anything that's brought against me because of that contract.
Thank you. And I know that you there are other questions, but Nicola has put a beautiful testimonial in the chat, and I'd like to read that at this moment, if you're open to that.
Awesome. That
She
sounds great.
says, I am learning equity jurisprudence from Julian and Margaret. It is truly life affirming. Their training is impeccable. This journey really resonated with me with peace and honor. I prayed for a remedy to the fight. Truth is being revealed here. Standing on the rock gives you a strong foundation to be in the world, but not of the world. They helped me with my employer to receive the complete fruits of my labors. It starts with standing for what you know is right, and it really goes to the heart of the matter. You face your fears, and you're welcomed into this lifelong community for support.
Thank you.
Thank you, Nicola.
So that's a lovely testimonial. And I know I will just add, as you had asked to give my thoughts, we've just completed the 13-week course with Julian and Margaret. And when they say advanced level, they mean advanced level. So having completed the 13 weeks, Personally for me, or just individually for me, I feel like now I'm ready to learn because it was like I needed that whole first set and it's intense. But now, okay, now I have the language uh, in a place where I can go, okay, if I start from the beginning again, which I will do in your next session, I can go, oh, okay, now I can put the whole thing in a context. And I remember you both saying that in there. You have to go through the whole thing. This is not A for the faint of heart or somebody who wants a quick fix. Now, just give me steps 1, 2, 3, and I can cancel on me. That's not this. This is learning foundations. This is learning a whole different way of thinking and being. And the integrity that you both show up with is absolutely inspiring. So thank you very much. And
Wow.
not for the faint of heart. So carry on. And I know that Bill had said that he wanted to also share his experience briefly.
Thank you so much, Esther.
Thank you. Yes.
Bill, go ahead.
Okay, my mouse disappeared. I couldn't find it. So people won't know this word because we don't use it very often. I wasn't overwhelmed in Julian and Margaret's course, but I was certainly whelmed. Oh my goodness. Like it was, wow. It felt like, I'm going through a storm. It was huge. But here's what it did. And I have an example that's not in the court because, I'm feeling still very strongly that I want to stay out of court. I don't want to do any of this stuff if I can avoid it. But now I know what to do if I'm caught. Esther and I are working with I won't give you any of the details, but we're working in something that 11 people are involved and it was getting messy. And we stepped in using the principles that we learned. And it took the rhetoric and it took the angst out of the whole game. Like it's just a new conversation going on. We haven't sorted it out. We've still got stuff to do, but it's got way less charge in the game. And I won't say we owe it to you two because equity is actually a pretty basic, brilliant thing. You do it with grace, and it's totally worth it, and it's astonishingly whelming. It really is. There's a whelming in it that I had no idea. And, I've got 2 years of pre-law, and whoa, this is one of those. So thank you very much for what you're doing, and we'll be seeing you again very soon.
Thank
Wow.
you so much.
Thank you so
Thank
much,
you
Bill.
all.
So
This-
thank you, Karen. I'll turn it over to you.
Thank you, Julian and Maggie. You both bring so much clarity to this topic. And I love the statement that you made earlier, and you've shared it too in our private member meeting, that equity allows the court of Babylon to become a court of consciousness where miracles can happen. I think that's just so beautiful. Thank you, everyone, for your great questions. And Esther, brilliant job. And I just want to thank both of you for saying yes to your soul path, Julian and Maggie, in teaching this. Again, we're so grateful for all you do. Maggie, would you like to end our podcast this evening with a prayer?
Thank you so much. Yes, thank you. Oh, Father, thank you for this beautiful group of curious, bold minds coming together in this fellowship. Thank you to Karen for providing this space for this. What a beautiful thing, and we're just so honored that we were brought here and brought together, and we thank you, Father. It just shows how you're working. You're still working, even when the world seems crazy and the enemy seems to be having his way. You still work to bring all of these beautiful people together, to learn together, to help each other, to support each other. And we just pray a blessing over each and every person here, that whatever you're facing in your life, there is a remedy, there is a way, there is help, there is support. And we just pray that blessing over each and every one. And we thank you all for being here, and we thank you, Father, for providing this, and we pray all of this in the name of Jesus. Amen.
Amen.
Amen. Beautiful words. Thank you. Thank you. Now, if anyone is interested in taking Julian Maggie's course, Karen Hanna has just put the image in the chat. And you can reach out to Julian and just let them know that you saw the presentation here on the Life First Canada podcast. And everyone, you're welcome to say thank you. You're unmuted, so thank you so much, everyone, for being here. This has been exceptional. Together we rise.
Amen.
Thank you, guys.
Thank
All
you.
right.
Hey,
So much,
everybody.
everyone.
Thank you.
Great questions.
Okay.
Thank you so much. Incredible presentation.
Thank you.
Bless you all.
Thank
Thank you.
everybody.
Thank you.